right, great. Hello, everybody. Welcome. My name is Nawi Ukabula. I am an associate here at Debevoise in the International Disputes Group, a member of BASIL, and a member of the steering committee for this event. I'd like to welcome all of you on behalf of BASIL and Debevoise to this joint Young ICA and BASIL workshop on improving the participation of minorities in international arbitration. I'll tell you a little bit about BASIL, offer a few opening remarks, and say some thank yous. This event is a sequel to a similar event that we had at the Tiller House in Washington, D.C. in 2016. And like last time, we are very pleased to see such a great turnout, and we think it'll be a very productive and thought-provoking discussion. So first, a bit about BASIL. BASIL stands for the Blacks in the American Society of International Law. It was founded in 2014 in response to a call from the then honorary president, honorary president of ASIL, Judge Gabriel Kirk McDonald. And its primary purpose is to remedy the underrepresentation of Blacks in international law. And part of BASIL's platform is using opportunities like tonight's event to do just that. We strongly feel that it remains important to stay engaged on this issue. Because despite studies that show that diversity improves productivity, the problem of underrepresentation remains a persistent one in international arbitration and in the field generally. When we approach the issue, I think we often assume that by and large, everybody is starting from that presumption. But sadly, I think it's important to recognize that that's not always the case. And just an anecdote. In the not too distant past, I was chatting with a colleague in the field that I consider to be very smart and progressive and forward thinking. And we were at a beach party, and I really just wanted to soak in some sun and sip some beach cocktails. But this colleague insisted on engaging me in a discussion about discrimination, which ultimately involved this person telling me that most of the time when minorities complain about discrimination, they're just using it as a platform to complain about imaginary discrimination. And so that's just one antidote, but I think a lot of times personal experiences can be more illuminating than all the statistics in the world. So I just submit that it remains as important now as it ever has been to remain engaged on this issue, to seek broader recognition of the problem, and seek a broader base of support to find solutions. So now for some thank yous. We owe a debt of gratitude to Judge McDonald, without whose leadership and vision BASIL would not exist. She can't be here tonight, but she's certainly here with us in spirit. We are also grateful to Professor Adrian Wing, who is one of the BASIL co-chairs. And BASIL is very grateful to our Young ICA partners for their dedication in pulling this event together. We're also very grateful to Donald Donovan, who is the co-chair of the International Disputes Group here at Debevoise and proposed that Debevoise should host this event and has been a great champion of diversity in the profession. Thank you, Paula, and to the whole Debevoise team that helped organize the logistics. Thank you to all of the speakers and mentors who took time out of their hectic schedules and in some cases boarded trains and planes in order to make this event happen. And of course, thank you to all of you for joining us. A few quick housekeeping matters before welcome remarks from Young ICA. Many of you may have signed up for the speed networking session. It's just like speed dating, but no kissing. It's going to take place in parallel with the cocktail reception next door. So after the main program, if you just stay in your seats, we'll give you further instructions on how that's going to work. Debevoise is recording this event for CLE credit. And those of you that view this event for CLE credit in the future, make sure to download the CLE credit form and listen for the verification code that we'll offer at the end of each panel. And so without further ado, I'll turn it over.
It's a biennial congress, which is one of the largest conferences dedicated to the practice of international arbitration anywhere in the world. The next ICA Congress will be held in Edinburgh 2020, and registration for that is open. Also, ICA engages in other projects such as the ICA project on third-party funding, the ICA Issues Conflicts project, and currently ICA is partnering with the New York Bar Society Association, New York Bar Association, and then the International Institute for Conflict and Prevention, International Institute for Conflict Prevention and Management, to make sure to address an issue in international arbitration with respect to cybersecurity. That also task force is currently ongoing. Young ICA for its Young ICA was established about 10 years ago, which one of the main objectives of which is to further open opportunities for young practitioners on international arbitration. At present, there are about 4,300 members of Young ICA all over the world. So if you're not a member of Young ICA, please, you're welcome to join. Registration, you can find registration at the website youngica.org. There are 4 activities that form the pillar of the Young ICA's objectives. The first pillar of Young ICA's activities is the skill building workshops. We organize skill building workshops all over the world, most of which focus on underrepresented regions such as Africa, but then also organize skills workshops in the US and other very developed regions. Those are some of the workshops that we have upcoming next month. The one coming up tomorrow in Warsaw, Tokyo, Prague next month, and a couple of those others in November. The second pillar of activities is mentoring. We have the ICA mentoring, which seeks to connect mentees with a mentor and a buddy. Typically, the mentor is either an ICA governing board member or a very experienced international arbitration practitioner. And then the buddy is usually a very senior or a senior associate or of counsel with a lot of experience in international arbitration. Some of the mentorship activities include in-person trainings with the mentees, meetings on the sidelines of arbitration conferences, and also helping all the mentees with publishing articles by working with them jointly. A third part of what we do is the Young ICA scholarships. At present, we have 3 of such scholarships with the University of Miami, one with MITS in Switzerland, Geneva, and then there's the Young ICA Tinshua Law School Scholarship in China. The fourth pillar is the Young ICA blog, which we use as a forum for spotlighting issues, but also more importantly for putting young practitioners out there in the spotlight as either thought leaders international arbitration. So those 4 pillars comprise and constitute the major thrust of what we try to do in terms of giving opportunities to young practitioners, most of which we are also very young practitioners, but then this also gives us the opportunity to get a lot of experience that we would otherwise not get, and also to gain exposures to certain other areas or aspects of arbitration that we might otherwise not gain. So we're happy to welcome any person here who isn't already part of Young ICA to join us by going to youngica.org. Thank you very much.
There will be a pop quiz on all of this after the cocktail. All right, so it's time for us to move on to the main show. And we are very pleased to have a master of ceremonies to do this for us, a keynote speaker, Professor Benjamin Davis of the University of Toledo. He's a faculty member there where he's held tenure for over a decade. He teaches arbitration, public international law, and international business transactions, among other subjects, and has had a distinguished career in the private sector prior to that I'll tell you about in a second. But backing up, Professor Davis graduated from Harvard College, Harvard Business School, and Harvard Law School, which I think is a trifecta. He then entered the private sector, becoming, among other things, the American Legal Counsel at the International Chamber of Commerce's International Court of Arbitration. While he was there, he supervised either directly or indirectly over 5,000 international arbitrations and mediations, as well as assisting in drafting the arbitration laws of India, Sri Lanka, as well as several other countries. Back in the early 2000s, Professor Davis had an idea that was, I think, before its time. He set out to do a quantitative and a qualitative survey of the practitioners in the field of international arbitration. So without any established tools to do this, he did what I think any entrepreneuring researcher would do. He sent out invitations to over 200 people, counsel, arbitrators, experts at the highest level of the practice. And he asked them, can you fill out a 20-minute survey? Many of the questions in that survey related to the implication, or rather the participation of minorities in international arbitration. Of course, he only got about 64 replies, but out of those 64 replies, he was able to compile results that are still today very revealing. In a 2003 article that he published with the American Review of International Arbitration, Professor Davis reproduced some of the quotes that the respondents of this survey filled out. I'll read just a couple so that you get the idea. In spite of the fact that American firms or American law offices were involved in some of my cases, I never got the opportunity to meet members of American minority groups. I have the impression that members of American minority groups are hardly participating in transnational business transactions. That again is in the early 2000s. On the basis of those survey results, Professor Davis described what he termed a color line in international arbitration, essentially excluding US minorities from the practice. That article was published 16 years ago, but it's still strikingly relevant to this day. Last year, Arbitral Women recognized Professor Davis as their 2018 Champion for Change. He continues to produce highly cited, incisive publications, including an article entitled American Diversity in International Arbitration, which is the subject of his keynote today. Professor Davis, thank you for being with us and welcome.
Okay, great. Oh, hello. Thank you very much, everyone, for this opportunity. Thank you to Young Ika. Thank you to Basil for allowing me to be here from Toledo, Ohio. It's a great pleasure to be here with you. So my topic is diversity in international arbitration. If any of the technology doesn't work, blame me, okay? Because so let me start off quickly here with my presentation. So let's start off with international trade in blacks, a 2-minute summary. I'll talk while this works. Let's see, where is it? How do I get it to do the thing that I need it to do? Yeah, the first one is not this one, the other one, the other one. The other one will be the, yeah, there you go. All right. Can you just start that? Just start that. I'll make it big, okay? Okay, and then just start it. So this starts in 1550. Just please watch on any screen you want. International trade in blacks. You see these little dots going across. Those are ships with Africans enslaved coming to the New World. And on the African side, obviously there were people who were getting those folks. There were folks who were grabbing those folks. There were folks who were being put into the boats. And there were folks who were driving those boats across. Each of those dots is a different boat with a different number of people. And it just runs through these years. So those are people going going from Africa to the New World. And down at the bottom, there's a sort of a total number vision of it. So this part of international trade, black people have been in a long time. But this is only part of it because obviously Africa did business in China, other places too. This only takes 2 minutes, but just watch the dots as you watch as the years go by. We're about 100 years after the first 1619 at St. Jamestown. At this point here, we'll be coming up on 1772, which is the Somerset decision in England, which said that slavery could not be allowed there. Let's see, we're almost there. Here we go. 1750. I think that was the French and Indian War. Anybody remember that? Or the Canadians called it another thing. And we invaded Canada at the time. That's what my Canadian wife tells me. So then we get to 1776, Declaration of Independence, all that stuff, you remember. And again, international trade. And people were making big money, okay? That was one of the things as opposed to just goods. The idea was with slaves, you could make a lot more money. That was one of the ideas about this, doing this. And as you can see, as we get in the 1800s, 1805, 1806, okay, that's the ending of the transatlantic slave trade to the States. So what happens? Everybody goes down to Latin America and to Caribbean, and then people get snuck up to Florida. And people are making big money in international trade. So those, as goods, I like to say, as cargo, obviously black people were involved in other levels too. And of course, what these folks were doing in the States was creating a lot of wealth for a lot of people. A lot of the bankers in London and insurance folks and in the Netherlands and all that made big money off of that. All right, so let me move on from there. So for anybody who says, oh, blacks aren't interested in international trade, we are terribly interested in it because we've been in it for 500 years. Now, back in the rationalizations at the time, this is from Pope Nicholas V of 1455's Romanus Pontificex, where he says, thence also many Guineamen and other Negroes taken by force and some by barter of unprohibited articles or by other lawful contract of purchase have been sent to the said kingdoms, meaning to the New World. And he talked about reducing them, these persons, to perpetual slavery. Some people translate the Latin as servitude or slavery and apply. So it was with the blessing of the Pope that this was going on. But don't worry, in the Muslim world, there were dilemmas about whether you could have blacks who were also Muslims who could be slaves. So, you know, there's a lot of heavy religious blessing of slavery that is pretty screwed up, but there we go. But that's where, and so it's old. So when we talk about today and the stuff that we talk about now, this is old stuff that we're talking about. And these rationalizations, back to even religious rationalizations, this is just very old stuff. So let's get forth to today. So let's do some statistics for Americans. For American women, this is based on my American Diversity and International Arbitration study. Significant number of American women, most likely white, in international arbitration in all phases of being counseled, but not so many as arbitrators. Basically, arbitral women started in 1994. Very few women in international arbitration. Arbitral women's worked very hard to increase the sisterhood. The sisterhood is worldwide. The sisterhood, if a woman and you're not a member of arbitral women, you are making a mistake, and you need to be a member. And they really have worked hard to increase with their pledge and all that, the number of women in the space, and it's had an effect. American minorities, a few American minorities active in international arbitration, all phases of being counseled, but even less as arbitrators. I added American lawyers with disabilities, infinitesimal numbers. American LGBTQ, self-identified persons, infinitesimal numbers. These four groups, the reason I put those in there is those are the four groups that are underrepresented in the American legal profession. So basically, women going up, minorities not much, infinitesimal and disabilities, infinitesimal LGBTQ, self-identified. And obviously it'd be good if all these numbers went higher among Americans. For the population, this is just your quick study. About 75% of Americans are white, 76, a little more female than male, 13% black, 1% American Indian, Asian alone, 6% Native Hawaiian, 0.2, 2 or more races, 2.7, Hispanic or Latino, 18.3, white alone, not Hispanic or Latino, apparently 60%. These are from the US Census. I didn't make this up. This is, you can get that on the internet. So you see the percentages of people, and then you're seeing who is doing it. And obviously, females are much lower than their percentage in the population, and blacks and all the minorities that are there are infinitely lower in international arbitration in the American side. Gender diversity in arbitrators. So this is from last year. You may have seen this. There's been some movement. All female arbitrators, various institutions are up there. Looks like the numbers are improving significantly from back when I was working years ago. Notice that the appointments of institutions tend to be higher, which suggests that when parties appointing arbitrators, they're discriminating against women. Okay, and that is like stories I hear from women, which are like, you put a resume in and then the woman gets excluded. Okay, and why? You know, what's this thing about women that's so weird that they can't be arbitrators, right? I mean, I don't know. Plenty of women are way smarter than me, way better lawyers and all that. And this is just a mind trip of some people in some law firms for whatever reason. I'm not only law firms, law schools, whatever. Okay. As to appointments by institutions, it is encouraging that institutions have done that. I'll speak to that in a little bit when I go along. How am I doing? 6 minutes. Okay, all right. Let's go. Why? Many theories. We talk about what implicit bias, explicit bias, what is it? Stereotype threat. What else? Another one? How about racism? Just the old nice one. Or how about misogyny? You know, let's just go with some of the fun ones. Like, you know, like what's another one I can go up with that's really, when you hate foreigners, what's that called? Xenophobia. Thank you. Let's go with that one. Oh, here's a nice one for you. Let's come up with some of the other ones. What are the other ones that we can come up with? Or really, how we hate people, huh? Maybe hate people with blonde hair like you. Hate people with no hair like you. Whatever the tricks are. You know, hate people with curly hair. What's all that hate, huh? Where's all that hate? Where does it come from, man? Or maybe you're from a different ethnic group, right? You know, like my great-grandfather will kill my great-grandson will kill your great-grandson. All those trips. How about the Irish and the English? You want to have a little fun there? How about the French and the English, or the French and the Germans? I lived in all that stuff. I spent years working on all that. All kinds of, why people trip out. Why do people trip out, right? You tell me. Why do you trip out? Why do we do that? Fear? Fear? What are you scared of? What are you scared of? Look around this room, all these people. What am I scared of anybody in this room? Huh? What's about it? I don't know what your religion are, whatever, I don't know. What am I going to be afraid of, right? Okay. There's another guy here, Douglas Palawa, did another thing, sifting through the arbitrators for the woman, the minority, the newcomer. A new piece is saying, well, you know, we pick arbitrators based on what we need for the case, and so diversity is not an important part of picking arbitrators. That's true. I pointed out to the guy, because I like him, that newcomer breaks into 2 groups. The newcomer who's the true newcomer, and the newcomer who is the son of or the daughter of a player, okay? Because the son of or the daughter of a player magically can get on a route that somebody who's a newcomer, who's just kind of a newcomer, is not going to see. I have seen it because they used to be my interns, so back in the day. As to women, I've talked about that. As to minorities, I, again, have talked about that a little bit. All right. I don't really buy any of the theories. I don't know. I mean, they may be true. I can't tell you. You know, I don't know. All I do is come back to this. This is me very recently. Actually, it's 1998, and the gentleman next to me, in case anyone doesn't know, is a white man. His name is Michel Godet. He's passed away now. He is a former legal advisor at the European Union in 1958. Gentleman down in the corner, on the left corner there, that's Fali Nariman, who is Indian arbitrator, lawyer. Guy smiling in the middle is Paul Gélinas. He is a Canadian, okay? Gentleman to his right, who's black, is Judge Ba. Judge Ba was the first judge to head the Common Court of Arbitration and Justice of the OHADA. And this was a day I organized to honor Michel Godet. Yes, this black American honoring a white old man, white, stale, and male, or whatever they say, white, stale, pale, and male, right? Why? Because why? Because he was the guy who was the president of the court when I went to work there at the ICC. And he was a person who was very, very much into dialogue with all kinds of people. I mean, he's one of the people who created Europe, and as every European here will tell you, getting 27 countries to agree on anything is a hell of a deal. Well, he was the one who had that vision back in '58, man, before you were born, about trying to pull that together, try to make that happen. And to be with the spirit like that was a really extraordinary opportunity for me. And 3 days after I started working at the ICC, the ICC, when he was the chair, replaced somebody in a case, and the parties weren't happy, and all of a sudden we had a case in the Obergericht de Zurich, Canton de Zurich, that wanted to come after us for our decision, and the Obergericht asked us for a statement about why we had to do it, and it was one of my cases. I'm 3 days on the job. What do I know about arbitration? So I try to make little files to give to all the people who know stuff, and Michel Godet says to me, Mr. Davis, I don't need a file. This is your case. And everybody snickers and looks at me. I'm on the spot, got to figure it out. And that's one of the things I appreciate about him, is always being a person who made you feel like you were the most special person in the world. For everybody, you were the most special person. That's the quality of somebody who teaches you to allow yourself to be on the international plane. Fali Nariman, another great person drafting the Indian Arbitration Act back in 1994, 1993, and millions of things. Jelinas used to be the head of the Commission on International Arbitration, Canadian, rich, bright, wonderful lawyer. I never got to work with Justice Boss, so I don't know. All I'm trying to show is there are some really great people, right? These are great people. Not just great men, but great people, okay? Now, I would add, most of the women here should note something about the picture. Maybe the men notice it too. Did the women notice it? Yeah, well, what I'm talking about, 1997, 1998, right? I talked about arbitral women starting up in when? 94, you know? There were women around that table. And in fact, that guy, Michel Godet there you're looking at, in 1983, or was it earlier, he named the first Secretary General of the ICC court at that time, who was a woman. Her name was Tia Maria de Hancock, 1983, even before arbitral women. And at the time, people had some issues with calling her Secretary General, so she got called Director. You know, all the trips that are going at the time. In fact, when I started working at the ICC, people used to sit around and say, can a legal counsel be a woman? Because, you know, maybe folks from the Middle East would not be able to deal with, you know, a woman and all this. I mean, people talking candidly, openly, right, like that, right? So around 1994, women, Eric Schwartz named the first woman, who was a French woman named Anne Cambournac, the first legal counsel of a team. The world did not end. I believe today there's like half of the people at the ICC court who are legal counsels are women. Guess what? It's working fine. Women are all over the world doing things. So whatever trips you have in your head as a woman about what you can do and what you're permitted to do, or people are saying to you, it's all nonsense. Okay, so you have a great possibility. So that's that picture. My conclusion is quickly here, only the numbers count, okay? Only the numbers count, how many are appointed in any setting. The great men that I've known are, some of them are really great, but actually there are a lot of people who are not in arbitration who are great men because they are doing cases, they're not acting as arbitrators because their law firms do not allow them to do it because it creates these conflict situations. So there are a lot of great lawyers who never get to be arbitrators. As to the great men, there are some, yes, but they're not as great as everybody thinks they are. Trust me, I got to know them real well, okay? And, you know, just like in every family, there's some great ones and there's some appalling ones, okay? So don't ever get tripped out on the great man theory of things, okay? Including about me, because I made mistakes along the way too. The freedom of party autonomy seems to be biased against minorities. Put another way, if we go back to the time of the slave trade, nothing new under the sun. All right. So I want to finish with this, which is my closing. I'm sorry, I am like 2 minutes over. Please forgive me, because I just came up with this at the last minute. So that's the other one there. There you go. So if you saw the end game, this is a scene at the end of that movie that I just loved, right? That just started right there. There you go. Hopefully it's, I'm happy for you. The sound is up, is it there? Thank you.
bumming me out is the fact I have to live in a world without Captain America. Oh. It reminds me.
Here you go.
Try it on.
Only a minute. Nods his head.
How does it feel? Like it's someone else's. It isn't. Thank you. I'll do my best. That's why it's yours. You want to tell me about her?
Stop it.
No.
Okay, so anybody saw Endgame here? Besides me? Huh? Anybody else? Anybody else go see it? I mean, they made $1 billion. Didn't you guys go? Anybody else go? Huh? Oh, thank you. All right. So when you saw this, you're like, wow, huh? You know, heavy, right? Right? Okay. I'm putting that up there for this reason. 400 years, black people been in this country doing stuff. You notice he looks at the first guy, who's the Winter Soldier, to get permission to take it. He looks at the second guy to say, I will do my best and get. You don't need to get blessed by some white man to do what you need to do. You don't need to get blessed. He could have said it could have been done, but that's not Hollywood. He said, I've been carrying this for 400 years. I don't need it. There we go. Thank you very much.
Thank you so much, Professor Davis, for an engaging, insightful, and informative keynote presentation. My name is Theomnique Nottage, and I'm a litigation associate in the litigation practice group of Higgs & Johnson, based in Nassau, the Bahamas. And I am one of 3 co-chairs of Young ICCA, and I'm here to move us along this evening to the first panel entitled, Can I Get a Diverse Tribunal? The speakers and the moderators for that session have joined us. And this panel's title is a reference to the Jay-Z song, Can I Get a, featured on his 3rd studio album, Hard Knock Life, Volume 2. But unless you're a close follower of arbitration news, or you've read tonight's program extremely carefully, you would not have probably or likely have heard of this. But you may wonder what the connection is between Jay-Z and the participation of minorities in international arbitration, and that is what our moderator and panelists are here to explain to you. So I'm delighted to introduce you to Uchiora Onwumegebu. Please forgive me for the mispronunciation. And he is an international attorney in Aaron Fox's international trade practice, and he's based in Washington, D.C. He provides advisory services and acts as an arbitrator in international disputes. Prior to Aaron Fox, he was senior counsel at ICSID for over a decade. His career has also spanned time at the United Nations Compensation Commission in Geneva, as well as private practice in Nigeria and United Kingdom. He is a senior fellow at the Center for International Governance Innovation, a member of the panel of arbitrators of several institutions, including ICSID and the Court of Arbitration for Sport. He has published and spoken extensively on disputes between governments and foreign investors around the world. Uchiara, the floor is yours to introduce the panel speakers.
So thank you, Theo. And I should also start by thanking the organizers of this event, Matt, Nawi, Prince, and Tolu, and the rest of the team. We have a very strong panel this evening for you, and I'll just quickly introduce them. First is Randa Adra. Randa is a counsel at in the New York office of Caroline Moring, where she practices in the international dispute resolution and litigation groups. Randa represents clients in both international and domestic disputes, including international commercial and investment arbitration matters, with a focus in the Middle East and North Africa. She also works on a broad spectrum of litigation matters that include class actions and multi-district proceedings, as well as maintaining an active pro bono practice, primarily focusing on representing Middle Eastern clients in asylum and refugee resettlement proceedings. Next is Nana Frimpong, who is counsel in the King & Spalding's Special Matters and Government Investigations practice based in Atlanta. Nana has broad experience representing clients in the white-collar criminal defense matters, internal corporate investigations, and government enforcement actions and international disputes generally, with a particular focus on the African continent. Prior to her time at King & Spalding, she was an assistant U.S. attorney in Chicago, where she was lead counsel on dozens of federal felony investigations and successfully conducted multiple jury and bench trials, as well as briefing and arguing appellate matters. Nana is spearheading an initiative that is actively promoting her firm's deep experience in anti-corruption and compliance consulting matters, as well as international arbitration matters relating to sub-Saharan African jurisdictions. She's originally from Ghana, though raised in Botswana. Our third speaker is Muhannad El-Mutadi. Muhannad is an associate in the International Arbitration Group at Curtis Malay, here in New York, where his practice focuses on international law, investor-state arbitration, and international commercial arbitration. Muhannad has acted as counsel for states, national corporations, and state-owned and commercial entities in several arbitrations under different arbitration rules. He has particular expertise in disputes relating to production sharing agreements, concession agreements, and oil and gas and construction matters. Muhannad also regularly advises governments and state entities on matters such as enforcement of arbitral awards and treaty interpretation. Now, I've taken time to painfully go through their backgrounds just to give you an idea of how diverse the panel truly is. And that's important for the subject that we are about to tackle. It's a somewhat sensitive topic, and you'll find that generally people would avoid or skirt around this topic. And it takes people like Professor Ben Davis and his brilliant scholarship on the topic to keep it in focus. Now, today, it's also thanks to Jay-Z that we are here. To some, Jay-Z is a brilliant rapper. To others, he's a business mogul. And to some, he's just the guy who's married to Beyonce. But for us in the practice of international arbitration, Jay-Z made quite a splash recently when he brought the issue of diversity in arbitration to the New York courts. Now, the matter has been very widely covered, so I'm not going to go into the details, but very briefly, sometime after Jay-Z sold his clothing brand Iconics, the company brought an arbitration under the AAA rules against Jay-Z and several of his companies, seeking about $200 million, claiming that Jay-Z had breached the sales contract by producing similar merchandise using the trademark of another of his companies. In the course of the constitution of the tribunal, Jay-Z petitioned the Supreme Court of the state of New York to suspend the arbitration on the basis that he could not identify a single African-American arbitrator on the AAA roster applicable to the case, who was qualified to preside over the case. Now, the court granted a temporary stay of the arbitration, and that's when the matter hit the news. The petition has since been withdrawn, was withdrawn before a full hearing of the application, and AAA, I understand, is taking steps to address the issue. So that's the background in a nutshell. Like I said, we have a fantastic lineup of panelists here to address this, and to make the best of our time, we've devised a different system which will be based on questions and answers, and then we'll open it up to the audience. So with that said, I'm going to rejoin the group, and with the first question going to Randa. What would you consider, or going to the panel with Randa taking the lead, what would you consider to be a diverse panel?
Hi, everyone. I'm really excited to be here. Thank you for having us. And this is a very important discussion that we should be having, and one that I think it's really important to keep in mind the context. So when you talk about the Jay-Z case that was just described, that's a U.S. case under, I believe, New York law with U.S. parties. And that is one type of case, but people who practice in international arbitration know that those aren't all the cases that we face, and there are some cases that are based in the Cairo Regional Center that are fully in Arabic, and other cases that are based at the ICC in Paris that are in other languages and based on other laws. And so when you keep in mind that context, I think the answer to the question changes. You know, what does diversity look like in France and Egypt and in the US and New York, right? So Jay-Z's concerns are very justified in terms of looking at the U.S. landscape or options for arbitrators and not seeing someone that looks like him or has his experiences or that he can relate to. But when, and I'll give a personal example of a matter that I've worked on, when you're working in Egypt under Egyptian law in an arbitration that's fully in Arabic with parties from all over the world, the pool of arbitrators is very limited. So how do you get a diverse panel in those cases? How do you ensure diversity, and what becomes the priority in terms of diversity? Is it race in those cases? Is it culture? Is it gender? Is it age? Something that I don't think we talk about enough. And it's a challenging question. So I would say that when you look at the various contexts, maybe in the U.S., race and gender become higher on the list in terms of what you look for in a diverse panel. But in the other example I gave, maybe gender needs to take a priority, especially given Professor Davis's example of MENA not having a great representation of women or acceptance. I can attest to the fact that I was the only woman with a speaking role in a room full of men over the age of 50. And it's 2019, and that says something about what we're dealing with here. And so, again, it depends. And I do think that we need to take small steps towards addressing this issue, because if we try to make every single arbitral panel across the world in different cultures facing different issues with different languages and different experiences, we will fail very quickly. But I think when you take this into context and you look at the situation you're dealing with, you have to prioritize what you can based on those cultural nuances.
Just wanted to add to that, completely agree with the notion that you want to be nuanced in your thinking about what diversity means. It's not, if your arbitral tribunal consists of 3 people, does that mean you need to have a woman, a man, and some sort of ethnic minority? That just seems a little bit artificial and not really, there's not much substance to that, right? Ultimately, in terms of, so if you're looking for diversity, that obviously has to be nuance as to how that's applied. All the same, one thing that I think I have found particularly interesting in the international arbitration space, we know that it's an area that there's real dearth in diversity, right? There's very few minorities, very few women. Actually, in the Jay-Z case, I was particularly amused that in response to the initial allegation from Jay-Z that, oh, we could only find one and you really have a really non-diverse roster, the response was, we have 28% of both women and minorities, and that was the response. And obviously, there's something shameful in that in a country where there are usually more women than men, that the most you could come up with was 28%, both of women and minorities. But one thing I would say that in the international arbitration space that I do think is a bit troubling is that there is such a focus on women, so the gender aspect. It's obviously safer, and perhaps that's, incremental steps make sense because you can have, much more buy-in from people around the world. It's easier for everyone to say, this is shocking, women are half the population, how can they be 20% or so forth of the arbitral appointments and so forth. But there's too much of a focus on the gender aspect and not on ethnicity or national origin. And given that that institution is necessarily one that is, trans-ethnic, trans-legal, transcultural, that international arbitration should be looking to embrace diversity more broadly.
Mohanna, do you want to add to that?
So yeah, frankly, I certainly agree with both my colleagues in saying that the answer to that question depends on the circumstances of the case, and actually so many factors, including, in my opinion, whether it's international or domestic, whether it's if it's domestic, then in which country are we talking about, who are involved, the parties involved in the case. So there are so many factors which you have to take into account when you decide which factor is the most important thing that you should take into account in making sure that the panel that you have is diverse. For example, if you are dealing with a purely domestic arbitration that is between individuals, as was the case with Jay-Z, then maybe factors like the race or the cultural background or the sexual orientation might be the most critical factors that you want to take into account in making sure that the panel you have is diverse. But if you are dealing with an international context where you have different parties from different countries and maybe different applicable laws, or at least parties from countries that apply different types of law, then you would think that other factors might be the most critical factors that you have to consider in making sure the tribunal is diverse. For example, whether or not the arbitrator is a common lawyer or a civil lawyer, for example. That might be a consideration. The language spoken by the arbitrator, the education, the bar admissions, the training, where he received his training. So I certainly agree that there's no one answer to that question. And I think that it's, but having said that, I think the goal is always the same, which is to make sure that you have a panel that's as representative as much as you can to the different competing interests in the case, and that you do not end up with a situation where you have somebody feeling, as probably Jay-Z felt, that his views have not been or are not being appreciated by the panel.
And that kind of leads into the next question, and it's one of the points that the Supreme Court Justice raised in that application from the transcripts. Why does it matter? Why is it necessary? Are we saying that a homogeneous panel, tribunal, cannot decide the case properly? Why is diversity necessary? Mohanna, you want to start?
Well, you know, I think this is a very tricky question because, in my opinion, the reason why I think it's tricky because normally when diversity issues are raised, including in the Jay-Z case, the first question that's asked, whether or not a specific person from a specific background or somebody who speaks a specific language or somebody who has received a specific type of training or somebody who is man or woman would decide the case differently from someone else who is from a different country or speaks a different language. For example, I think in the Jay-Z case, when he made the application, the first question that was asked by the judge was whether or not the lawyer for Jay-Z was suggesting that an African-American arbitrator would decide the case differently. And that same question is always raised when questions about gender is raised, whether a man would decide the case differently from a woman. And in my opinion, that's tricky because in my opinion, that's not the issue. That's not the problem. I think the problem is bigger than that. The problem is one that has to go with, in my opinion, goes with perception of the legitimacy of the process in the eyes of the subscribers to that process, who are the disputing parties. So it's not enough to say, I mean, it could be, frankly, I don't know the answer to that question, whether a man would decide the case differently from a woman. But for me, that's besides the point. The point is whether or not we are making sure that the panel we have is representative as much as we can to the competing interests in the case. So on that point, I want to highlight the fact that even though arbitration is now so prevalent and has become an acceptable way of resolving disputes, especially in the context of international and transnational settings, that was not always the case in many countries, or at least well, certainly many countries, but let me talk specifically about the Middle East and the oil-rich countries. Arbitration in the 70s was even prohibited in some countries. In Libya, where I am from, it was always was not looked at favorably, especially after the different arbitration cases were brought against the country following Libya's nationalization in the 1970s of different oil concessions. So the point I'm making here is that even though different agreements, for example, the New York Convention or the UNCITRAL model law now require states to give deference to foreign arbitral decisions, in my opinion, that difference derives from the trust in the process. If that trust is lost as a result of a perception that the tribunal we're having are not representative of or not diverse enough, then you might have serious issues regarding the enforceability of the decisions. So I think, as I said, it's a very sensitive topic and one that goes beyond questions of whether or not people from different backgrounds would decide the case differently.
Yeah, I completely agree with Mohammed on his response there. I think it's easy to focus on the who would decide things different and so forth, and not think of the broader context of why diversity matters. I think it's perhaps helpful to step back. One of the initial impetuses for diversity initiatives was it's really the right thing to do. We're in 21st century. Shouldn't you really have your institutions reflect the communities which you serve or the customers that you provide services to, and so forth? But that's not really compelling if you're running a business, you have a bottom line, you need to create value and make quick decisions. Who has time to do the right thing if there are big important decisions that you need to make very quickly? So it's not very satisfying if that's just the only reason for diversity. And probably the last 10 years or so is when a lot more empirical studies have come through, where people can say there's a real correlation between a diverse workforce and actual positive business returns. There are great studies, such I think McKinsey's from 2015 or so, showing marked differences in the performance, statistic differences, like 35% more than the medians in their own, in the same industry in terms of outperformance if they are a diverse company, incorporating diverse perspectives and so forth. So I think that's just an important backdrop. of course, some of the responses to that are, well, international arbitration is not a business, right? It's more akin to, this is adjudication, right? So we're dealing with, this is more like a court or a court and jury. And how are some of these empirical studies, can you bring them to bear in this context? Are they applicable? And I think Mohanad really outlined why they are. Because to me, there are really two reasons that I think are compelling for me why diversity does matter. And I think those all draw from those empirical studies as well. So the first being, I think this is pretty non-controversial, and this is something I think the judge referenced in the Jay-Z case as well. Yeah, diversity is a good thing. I don't think anybody really thinks sort of broader perspectives could ever be a bad thing. And that sort of ties to the initial comments that Rhonda had at the beginning. Like, you're going to have a diversity of perspectives, particularly in an institution that, you know, necessarily is dealing with multicultural issues, multilingual, multi-jurisdictional issues. People who are able to navigate that easily is obviously better for a perspective of reaching sort of a more thoughtful decision. But beyond that, I do think, and this is the point I think Mohanad made, which I completely agree with, there's a legitimacy issue. And for an adjudicating body, you need to have legitimacy. And I think the real threat to international arbitration as an institution over time is going to be the legitimacy issue. Because how long can you have an institution that's largely then seen to be run by one ethnic group of a particular gender, of a particular age, when the rest of the world does not look like that? I think one of the reasons the ICC, for example, the International Criminal Court, faced a lot of legitimacy issues in Africa was in terms of, you know, the sense that they were targeting African strong men. This is similar to some of the issues you have here in the U.S. with, African Americans in certain communities and police officers. So the sort of legitimacy aspect, I think, is such an important part of people buying in and ensuring that your stakeholders are with you. So to me, it's really those two reasons why you want diversity ultimately in the institution of in the international arbitration institutions.
Thanks. Rhonda, Nana talked about the adjudicatory systems, and this raises the question, is this diversity issue peculiar to arbitration, or is it something that cuts across board? And if it's that critical, how come the other systems have not are all surviving?
Well, I think yes and no, really, because as we all know, if we've been in a courtroom or a conference room, there's a lack of diversity problem across this industry, generally and broadly, from all aspects. But international arbitration presents a unique challenge for all the reasons that Mohanad stated earlier, which is that there are so many competing priorities for counsel. And I think this might actually explain some of the statistics that Professor Davis presented earlier, which is that institutions tend to put forth or nominate arbitrators that are diverse more often than counsel, because counsel are thinking about, you know, the slew of matters that you referenced before, which is, you know, you're looking at the experience, the language, the experience with this type of law, common law versus civil law experience. There's just so many other factors. You know, where does diversity fall in that spectrum? Do we prioritize it over and above their experience with a certain jurisdiction, with a certain type of issue, a certain industry? Probably not. And I think institutions are able to take that step back and be more thoughtful about those issues because they don't have a stake in the game, right? And so, yes, there's that aspect of all these competing priorities, which makes international arbitration particularly challenging when it comes to ensuring diversity. And again, some of these cases that we deal with are just, the lack of diversity is baked into the circumstances. When you have a pool of 15 arbitrators that are fluent in a specific language, you know, how do you ensure that you're picking the ones that will represent a diverse perspective or that come from the right, that have the experience as well as speak the language, as well as understand the jurisdictional law. You can't win, right, to a certain extent. So it is a little bit unique and probably more challenging in this profession, which I think just means we have to work a little harder to make sure that we do better and that we do improve the shocking statistics that are still out there, the 28% figures that we see. And another thing that I think we forget is that in this industry, we tend to put a very high priority on experience. And so every time I've been part of a discussion about nominating an arbitrator, well, do they have a lot of experience? How many years of experience? Even clients that I've spoken to, they just always emphasize, well, do they have 25 or more years of experience on an issue? And if we're only nominating and appointing the same people that have had experience, then we're not allowing new people to enter the industry, to enter and try out being an arbitrator and proving themselves. And again, to reiterate what was said earlier, there are probably a lot of great men and women out there that we don't even know about, because this is such a small niche area where you appoint the same people and it's almost like a brand name thing. And that just makes the barriers to entry so high that it almost becomes impossible to solve the problem. So if we don't start changing the mentality in this industry and the fear of change that we all have, we love to stick to what we know, then we're just not going to see the progress that we want to see.
Thank you. I guess that takes us back to the original question. Can I get a diverse tribunal, and whose duty is it to ensure a diverse tribunal? I think this is the crux of the matter, and it's a question open to everyone. Muhannad, do you want to start?
Well, yeah, if I may. Well, I think that it's the duty of everyone. Everybody who's involved in the process has a duty of making sure that the panel that we have are diverse. And everybody, by everybody, I mean specifically the institutions and the disputing parties. And I want to emphasize that it's also the duty of the disputing parties, because oftentimes institutions are blamed for issues with diversity, where the fact of the matter is that in most cases, the disputing parties retain the power to appoint both the counsel and at least 2 of the 3 members tribunal. And actually, in many cases, they also select the chair by agreement. So I think that the greater weight of the responsibility lays on the disputing parties. And here, I think I want to mention that one of the biggest challenges that we have on arbitration, as far as making sure that tribunals we have are diverse, is, in my opinion at least, the fact that the disputing parties are not normally interested in making sure that the panel that they have is diverse. Normally, what they're driven by is their interest in making sure that the appointment they make is someone who will increase the likelihood of them winning the case. Or if their case is so bad, then at least somebody who will increase the likelihood of minimizing the loss. And another, I think, challenge is that oftentimes the disputing parties do not want to try somebody who's never been tried before. They're looking for a known quality, somebody who's been tried before, somebody who has been at least tried by the counsel who's representing them. So in my opinion, all of these issues create, all of these factors and challenges create a lot of problems in making sure that the panels we have are diverse. However, having said that, I think that the institutions can, in fact, play a major role in trying to resolve that issue by making sure that the rosters they have are as inclusive and diverse and representative as possible, so that at least, when you have a situation where you need to make the appointment from the roster, as was the case in the Jay-Z case, you're not going to have somebody who says, I couldn't find somebody who's, who's at least representative of my culture or my views. So I think it's the duty of everybody, and as I said, if I'm going to blame somebody more, then I think it's certainly the disputing parties more than the institutions. And in fact, I read in one article that there was a study on the appointments which were made by exit for chair people, right? And that study found that the chairmen who were appointed by the exit were more diverse than the appointments which were made by the disputing parties. You know, disputing parties usually go to the same guys, to the same known names. So I think it's everybody's duty. Yeah.
Perhaps maybe just to add to that, I mean, I think it makes sense, right, that the appointments go to the same people because there's a real information vacuum that's not there in other arenas and in legal practice, right? So if you are a very well-known class action lawyer, that could be, you could be a minority, you could be a woman, because yes, there's still barriers to entry there as well, but it's not so closeted, it's not so difficult to gain that type of expertise. You know, I tend to be a little bit of a pessimist when it comes to people just sort of doing things out of the goodness of their heart and, you know, really needing to see value for themselves as to why they'll want to take a particular action. And it's a real challenge in international arbitration to break past that because, you know, with all the great strides we hear about in, you know, companies within the U.S., like general counsels insisting upon diversity in law firms and so forth, and requiring them to have, you know, lawyers all the way from junior to senior who have diverse backgrounds. Some of the criticisms of that is that whenever it's some bet the farm type of case and it's a really big something, they're going to take something safe. Nobody has time to think about diversity. You want the issue, you don't want your company to go under. And I think it is worth underlining that if you face a significant international arbitration, you don't want to roll the die with somebody you don't really know, you can't really get that much information about. So I think to Mohaned's point, there has to be a way to try to gather that type of information, because otherwise I don't see how that loop ends. You know, whether it is, you know, some of the efforts you hear about where independent entities like third parties try to collect data about arbitrators and so forth. So you could be in an arbitration and you think Rhonda was an amazing arbitrator. She, you know, wrote amazing opinions, was very efficient and so forth, conducted hearings with precision, but just a small group of people know about it, and that information doesn't spread out. And so I don't know if there are things that the arbitral institutions themselves could do that are imaginative to, I don't know, not issue the final award until you actually write some sort of a review with respect to the arbitrator or the counsel, some means in which information is being gathered about the abilities of the people doing the work and their, because other than that, you're going to be in a position where I need to pick somebody and I don't have time to think about diversity. I just want to make sure that somebody is good and competent and can get the job done.
So, Rhonda, do you see a role for parties in this? Do you think it's realistic to expect parties who are faced with a large dispute, for instance, to start focusing on diversity? I mean, is that, would you consider it their duty?
Well, I just want to start by saying thank you for that peer review. I do issue awards with great precision. And if anybody has an arbitration that they need an arbitrator for, diverse woman over here. But to answer your question, I do think that the onus has to be on the parties. But to be more realistic, I think maybe there's two things that we can do, which is, one, there have to be guidelines out there. There are guidelines for everything. People love rules. They love lists. And for lawyers, it's a very safe space, you know, to point to something to your client and say, hey, you know, the ICC recommends this, the whatever rules, I recommend that. You know, if the institutions are putting the onus on the parties to have diverse panels when they're appointing arbitrators or nominating arbitrators, it gives lawyers and counsel an incentive to be more vigilant about that. We follow these rules when we're choosing, when we're looking at the rosters, we look at the rules, we decide what makes sense, and if diversity is listed in there, it's something that people will take into account, at least more, at least it'll be top of mind, which a lot of time it's not right now. It's not even one of the factors that come under or are on the radar. So that would be maybe the first option. The other, I would say, is to really have the institutions play a bigger role. You know, so many times parties are unable to decide on a chair for a panel, and everybody gets, and I've had this happen so many times at this point that, you know, all the chairs that are nominated are conflicted out or they've been objected to, and so the institution has to appoint someone. They should always make it a rule to appoint someone that either has not necessarily had the opportunity to get a substantial arbitration under their belt or is diverse and would offer a differing perspective, because then you help break down those barriers. And, you know, if the parties got their act together, they wouldn't have had somebody that didn't have that kind of experience or somebody that wasn't diverse if that was really something they were trying to avoid. But the institutions have that power both to implement such guidelines and that would really set parties and councils straight and put the onus on them more, as well as to give opportunities to newcomers, to people of color, to women, that would create more opportunities that would then allow, it would snowball into allowing these people to get more opportunities because, again, word of mouth passes very quickly in this industry.
I've got more questions, but we're running against the clock here. Perhaps we should open it up to to everyone. First question, please. If you can start by stating who you are, followed by the question, please. Yes.
Yeah.
Okay. So I've been furiously writing. My name is Jill Pilgrim. I have been practicing law for 35 years. I'm an arbitrator for FINRA, for the securities industry, for the American Arbitration Association, and I'm a hearing officer for the New York State Gaming Commission. And I'm going to try really hard not to discuss many of the points that I have, because I was getting very agitated hearing the comments that were being made, or sort of the assumptions. So let me start with my last comment. The arbitral organizations are selecting and vetting arbitrators. So borrowing a theme from the Me Too movement, start by believing and understanding that every person on the list is competent, okay, whether they're a woman or a minority. And the note that I wrote here is, maybe your case just sucks and you deserve to lose, right? I mean, it's not, you can't blame it on the diverse panel, right? Because at the end of the day, you've got the law and the facts, and it doesn't matter who it is, they're applying the law to the facts and they're making a decision. So all this stuff about, you know, we can't find women. Women are blowing how should I put, what's the word? Women are, I see awesome women in every aspect of the world. If you look at the United Nations, you look in companies. So we have all these competent women, but all of a sudden we can't find an Arabic speaking woman to be on a panel. That doesn't make sense. So something else is going on there, okay? So I hope you won't be pessimistic. And let me just give you some examples of why diversity matters in answer to the question that you asked, and then I promise I'll stop talking. Some of the things that occur to me is from cases that I've had, is that if you are, that's just because we're beating up on them all the time, an older white man from a upper middle class background, right? Your assessment of credibility and understanding of certain witnesses and situation is going to be different than a diverse person. That is why diversity matters. Because if I'm Jay-Z or first of all, every dispute doesn't just involve issues that only white men understand, right? It could be a female-centered, a female company. It could be a female clothing store. It could be a female business, whatever the issue is. And so to tell me that an old white man is going to be able to make a better decision than a woman with exposure and experience in that context just doesn't make sense. So there seem to be these assumptions being made that for some reason only a certain group of people have the type of experience that's relevant. So that, you know, if you're dealing with a boating accident case and you have a bunch of people on your panel who have never been on a sailboat or never been on a boat or don't know what the, don't understand nautical stuff or whatever the issues are. Or if you're, I had a case once where there was an issue of whether a party had received notice, and the other folks, the person I was the arbitrator, the hearing officer for the person prosecuting, was sort of presenting like, well, of course this individual is pretending that they didn't receive notice. Well, this individual had been in diversity on panel. I'm sorry. I'm going to stop.
That's really, thanks for your contribution. I wanted to press a little bit on the comment, because I think you're exactly right? Diversity does matter because of that broader perspective that you get, the enrichment you get from different backgrounds, upbringing, socioeconomic background, and so forth. But when we're dealing with resolving disputes, so if somebody crashes into my car and I want to bring some small claims before a simple court, the reality is I may have a judge who may not have had that experience before, who may not have my particular background, who may not have whatever additional particular factors would make a more reasoned decision, a more thoughtful, nuanced decision, because he really wasn't walking in my shoes. I guess the point I'm making is that reality is there, and I don't think we can completely work around that. You're not gonna always have an arbitration tribunal that completely reflects your particular experience, and I think it's maybe unreasonable to expect that. But I think we can insist upon a judiciary that's diverse. Judges talk. You can have some case, and then you go in the back and you chit-chat with your colleagues, and they'll say, oh, you didn't think about that? She might have been homeless. And that might be a perspective that may change your thinking or your ability to approach a case. So I think, yes, diversity matters broadly, but I think for us to insist on that type of precise experiential diversity is perhaps maybe too far to wish, because I just don't know how that even would work in practice.
We'll take another question from the floor. Mike, please.
There we go. So the point on the judiciary, I think, is an interesting one because it's sort of public-private, and I think it's one of the central problems for arbitration, because when we're looking at judges, at least in the United States, a lot of the same arguments were advanced forever. What difference does it make, that we have black judges or female judges? They just have to decide the case. A white guy can decide a case just as well as, so why do we have to worry about diversity? And I think we sort of, in the United States, we saw over time that argument sort of lose traction. And now I think most Americans, most practitioners would support the idea of a diverse judiciary. But it's part of the shaming, part of the fact this is a public institution, and shouldn't it reflect at some level the breakdown of our society? Arbitration, though, sort of has the problem of being a very private institution, and it combines two of the worst things. It combines the very private, confidential nature, where you don't even want people to know what the decision was, and the fact that you're not talking about sort of a process in general, you're talking about a decision, and something that's really personal to the parties. I care very much about whether there's a $15 million judgment against, I'm going to do whatever I have to do, and we're not doing good here. This is not about I care about the world. I care about being able to tell my boss I didn't lose $15 million or whatever the issue is. So I think that the problem, I think, with the argument for obviously I support the argument for diversity in arbitration, but I think that the problem with the messaging is that there's still that disconnect from the idea of a lot of practitioners, particularly white practitioners or non-minority, non-male practitioners. I was at a conference about a year ago where a guy stood up, an older white male, not to stereotype too much, but he was an older white male, and he basically said, why, and we were talking about diversity, the topic was diversity in arbitration, and he got up and he said, why are we even talking about this? What difference does this make? I mean, let's go back to, he literally said, let's go back to the old days when we didn't worry about this kind of nonsense and we just focused on our jobs and we did what we had to do for our clients.
That's really gutsy.
Yeah, really. I actually was amazed by it, and I had to laugh because I was on the panel and I had to laugh at it. But it does show something in terms of that message is not filtering through to a lot of the practitioners. And so, I guess the question is, there's a question, how do we do that? How do we cross that divide in such a private institution where the parties' interests are so paramount? And the whole belief is that the parties can structure it however they want. It's all for the parties. How do we challenge that and get some of the successes that we've had in the public sector over into this very private?
We'll get to that in a minute. Is there another question from? Okay, one here and one there, and then I think we have like 4 minutes left.
Now, when we talk about arbitration in the public sector, we realize that we need diversity because this arbitration in the public sector is a default mechanism. It's taking away basically dispute resolution from the courts. There's been so much push in our society to make sure that the courts are diverse with regards to judges. How can we utilize this to shame the arbitral organizations, the providers, to say in the international community, this is a system in which maybe you should be arbitrating in a public manner, but you're not. But because you are, you have the same responsibility for diversity in international arbitration, even though it's private, just as though you were adjudicating this in an international forum. How do we shame them?
Well, again, we'll pick up on that. Okay.
So I'll just stand up. Hi, my name is Fakhruddin Walika. I'm from Pakistan and I study at Columbia. So my question pertains to what you said, that we don't need diversity just because it's the good thing to do. We need diversity because it will actually be beneficial for us. And I think that will be the driving force for diversity. And why we need diversity to save this institution, this mechanism of arbitration, is because by virtue of it being a private institute, which you said, the legitimacy of arbitration, especially investor-state arbitration, is already being challenged worldwide. Look towards Europe. There's talk of a court of replacing inter-European arbitration. The recent awards which are being passed, like coming from Pakistan, there was a $6 billion award passed against Pakistan, which was equivalent to the loan we got from IMF, sending the country into great financial problems. So money coming in from one end and the same money going out from another World Bank body. Therefore, I think the diversity is actually one of those things that can save arbitration from the crisis of legitimacy. And we all know that public perception and legitimacy is crucial in any process, be it court or be it arbitration, when the task is adjudication of disputes and dispensation of justice.
Thank you. And we'll just take one final comment, please. Comment question.
Hi, my name is Hind, and I'm a Moroccan student from Colombia also. And actually, my question is more, I want some testimonies, because what I am afraid of is, as a member of a minority, a woman, can your legitimacy sitting in an arbitral tribunal be questioned by somebody who can make you feel directly or indirectly that you are here just because we wanted to check the box, no? And just because thanks to a sort of an affirmative action.
Thank you very much. I think we are generally in agreement that this diversity thing is important, but we still haven't quite touched on how to make it happen. How do we make sure that we get a diverse panel? I could have thrown this out to my panelists, but we are running out of time. I've been in this business on the international level for quite some time now, well over 20 years, and I've got a few thoughts on that. Whose responsibility is it? Whose role is it? And really, I think it's somewhat unrealistic to expect parties that are faced with what could be in their minds life and death decisions to at that point be focusing on doing good for the greater world. You know, sometimes we're talking about life and death of the company, but parties do have a role, and that's because the whole arbitration thing is based on party autonomy. It's the parties themselves that choose to go to arbitration, and they have the power to design what they want, and that's the beauty of arbitration. And we've seen that happen. Now, it has to happen well before the dispute arises. Once the dispute arises, parties are no longer at that point focused on trying to bring peace to the world. They want to win. And so what happens is that in the instrument of consent, that's where the relevant provisions need to be put in. And it has happened. Under the ICSID Convention, the ICSID rules, for instance, co-nationals of parties cannot be appointed to tribunals. But parties can contract out of that. The US, Canada, and Mexico did that in the NAFTA. There are other treaties that are out there where co-nationals can be appointed. So that's one way to do it. Arbitration institutions have a very strong role to play. ICSID, I know, has been very progressive in this regard. One of the secretaries generals that we had in the past actually had there was a policy in place at the time when the institution had to make an appointment. A list being presented for him to choose from must include a woman. It must include someone from it must be a diverse list. And I know for a fact that some careers took off from that, just from that little act. At the end of the day, nobody is going to be forced down the throats of the parties. But this is a critical step that the institution did take. Today, ICSID, when it's approached to appoint, no longer just takes names from the list, from the panel. It looks around for potential candidates from all over the place and presents those names to the parties. And I've never come across parties rejecting someone because they're a woman or because they're a person of color. This is another step that does help. Now, finally, again, it's up to all of us to do something. For young ICA, I would say step up your game. You know, stay on top of your game. To quote Jay-Z himself, or rather, to quote him rather loosely, it's very difficult to teach a child to be a racist if his or her idol is Barack Obama. Actually, Jay-Z did say Snoop Dogg, but I think, but in present company, let's say Barack. So, you know, on that note, I think this is a subject that we can spend the whole night talking about. But there's a panel coming behind us, and I would like to please ask you to join me in thanking my fantastic panelists for a wonderful job. You're going to do that? Yeah.
Thank you to our first panel for such a thought-provoking discussion and to the members of the audience that contributed to that discussion. At this time, the natural follow-up to that panel is going to be a very brief dance party featuring Jay-Z's smash hit from 1998, Can I Get Up? No, I'm joking. We're not really going to do that because then we wouldn't have time for refreshments and a bathroom break. So we're going to take a short 15-minute break for people to use the bathroom and get refreshments. Again, for those of us that are, for those that are watching this in the future for our CLE credit, please download the CLE form listed under the resource section of the console. And for this panel, the code is 19246. Thanks. All right.
Okay, we're about to get started with the second panel. I'd like to ask everyone to please take your seats. So the second panel will take the form of a roundtable discussion on the question of whether a pledge is necessary and needed to improve the participation of minorities in international arbitration. Tonight, we are very pleased to have Natalie Reed as our moderator for this panel. Natalie is a partner in Debbie Boy's International Disputes Group, focusing on international arbitration, public international law, and complex commercial litigation matters. A Jamaican national, she regularly advises and represents multinational corporations, international organizations, and non-governmental organizations in proceedings in U.S. courts and international fora. Ms. Reed has acted as counsel in commercial and treaty arbitrations under major arbitral institutions. Besides this, she holds several leadership positions, most currently as a board member of the London Court of International Arbitration and president of the London Court of International Arbitration's North American Users Council. She is recognized by leading legal directories for her outstanding experience in international arbitration. She received her JD cum laude from Harvard Law School, where she was co-managing editor of the Harvard International Law Journal. She received her AB magna cum laude from Brown University, where she was a member of Phi Beta Kappa. Please join me in welcoming her as moderator to this panel.
Thank you very much, Theo. Since I have the microphone, I had warned my panelists that I would do this. I'm going to take a few minutes and use moderator's privilege or prerogative and offer my answer to some of the very important and provocative questions that were posed at the end of the last panel. Frequently happens is that once people get warmed up and you start getting questions from the audience, everybody's like, oops, we're out of time. I, unfortunately, will not be able to stick around after this panel, so let me lob my own thought grenade into the room and encourage us all to not just, sort of pick up on it in the questions that you ask our panel, but in the conversations that happen afterwards. So the perspective that I bring, and this is something we'll talk about, is very, very frankly, as one of the few black women, particularly black women who are not American, who practice at the highest levels of international arbitration. Because I'm glad he has come back into the room, I recognize that I have this role in many ways because of the support and sponsorship of people who are at the leadership position of this profession, such as Donald Donovan. And we'll touch on that and how important that is throughout the panel. So by all means, please give Donald a round of applause. So by virtue of the privileged position that I find myself in, after a decade and a half of practice, I am frequently on these panels in the position where our esteemed panelists from the first panel were, and I'm frequently asked, sort of challenged in the ways that our questioners challenged before. So one thing I have learned in the decade and a half of practice is if you can boil it down to 3 points, it's much more likely that people will remember it. So here are my 3 points that that I offer as answer, provocation, and challenge. First, I agree that we all bear the responsibility, and therefore we all have to challenge and explode the notion that there is a choice between diversity and quality. I believe that we would all agree with this. We are all nodding. But when we hear even the answers to and the descriptions of the challenges, we are frequently faced with the idea, well, parties may not think it is as important to have diversity when they care about these other things. It is not diversity or these other things. It is diversity in these other things. Second, we have to recognize that you go where the interests are. You meet people where there are. So you don't necessarily ask your client, who is a party in the one arbitration they will ever have, to listen to you about appointing a diverse tribunal. One opportunity is that you don't even talk to them about appointing a diverse tribunal. You just give them diverse candidates. But second, you recognize who the gatekeepers are to this profession, including the arbitrators. And those are the council, who propose arbitrators to parties, and the institutions. You will have heard in the introduction that Theo gave of me that I have a couple of roles in institutions. So even though I am not carrying water for those institutions, I will tell you that in the last several years, it is the institutions that have actually played a critical role in moving the needle in terms of women and gender diversity. Doesn't get to the question of minority, ethnic representation, and other dimensions of diversity, but institutions are playing their role. It is recognizing that council have a role as gatekeepers, and what we then look for, we are the ones who are repeat players. We are the ones who, when you look at the body, the college of people from whom we select our arbitrators, one of the things that, Professor Davis's statistics, both the earlier summary and the later article, remind us is, again, in what is a somewhat cliched phrase, that universe, that college of people from whom we select is still overwhelmingly not just pale, male, and stale, but Western European. You can't go to a particular client and say, I want you to go outside that college because of. What you have to do is say to yourself, as a gatekeeper for whatever that universe is, whatever that college is, if I continue to allow it to be overwhelmingly pale, male, stale, and Western European, what I am doing is either perpetuating or not opposing the unconscious bias that presumes competence in somebody who has that profile. It is to say that it's fine if we only pick our arbitrators from that, because you know what, that's fine. I'm going to presume, in the way that I think Jill mentioned, that if they're on that list, they must be okay. It is part of our responsibility in order to give our clients the options that they need and that many of them want and can become allies, that we play our role in increasing the diversity of that college. So, with all of that, I draw the line. I've lobbed my grenade. I thank my panelists for their gentle permission. And I move to the topic, not of course completely unrelated, of the second panel. If the first panel was focused on arbitrators and sort of, can I get a diverse panel? The second panel is about broader issues of diversity, minority representation in the profession as such. And the panel that we have assembled have been not just pleased to take up the charge, but prepped for the kinds of questions and discussions we'll be having. Their full bios are in the program, but very, very briefly. First, we have Apurva Patel, who is a senior associate at Wilmer Hale in DC. Purva's practice focuses on international commercial and investor state arbitration and cross-border litigation. In addition to his work as counsel, Apurva is a vice chair of the ABA's International Arbitration Committee and serves on the editorial board of the section of International Law's quarterly publication on international dispute resolution. As we can see from his presence here on the panel, he is committed to advancing diversity and inclusion in the legal profession, and his work in that space includes serving on the National Leadership Committee of the ABA Young Lawyers Division's Men of Color project and participating in many other similar initiatives. Next to Apurva, we have Charlene Yim, a senior associate in the New York office of Gibson, Dunn & Crutcher. Charlene specializes in investment treaty and commercial arbitration and also advises clients in relation to the enforcement of arbitral awards. Charlene also maintains an active pro bono practice advising clients on international human rights, international criminal law, and immigration matters. Finally, we have Jordan Wall, who is a senior associate in the New York office of Wilkie, Farr and Gallagher. Jordan specializes in complex commercial and international dispute resolution. He has represented clients before trial and appellate courts in the US and before US and international arbitral tribunals. He regularly advises his clients on issues relating to international dispute resolution, including extraterritorial discovery, forum selection, enforcement of judgments, et cetera, et cetera, et cetera. Our fourth scheduled panelist, Estefania San Juan, from the White and Case Miami office, sends her regrets. She was unfortunately unable to join us tonight at the last moment because of unanticipated developments in a client matter, things with which, of course, none of us is familiar. As with the last panel, and as I warned my panelists tonight, we are going to try and make this interactive, engaging, and interesting. So I have sort of a few questions that I'll be using to shape or guide the discussion. But as we are going through, if there are questions, comments that people would like to suggest, please put up your hand. We might collect a few and sort of weave that into the conversation. But what I will do is sort of ask a question and either say it's, throw it open to the entire panel, or ask one of my esteemed panelists to take the lead, and of course everybody can chime in. So I'll start where the last panel started, because we're really good lawyers and we like to interrogate terminology. So when we talk about minorities or diverse practitioners in international arbitration, who do we really mean, and what are we talking about? Minorities in the context of what population? Diverse as compared to what? Anybody?
Sure, I'll bite. Hello, everyone. I'm very glad to be here. I think to continue what was said in the last panel, it's a complex question. There are, of course, the very common ways in which we think about diversity and who counts as a minority, but I think that is very much enshrouded in what kind of perspective and what tradition we're talking about. Certainly in Euro-American experience, we talk about race, we talk about gender, we talk about sex and orientation. And all of those things I think are good and well, but I think we should challenge ourselves to expand that definition and that concept. One of the things that I think that's developed for me in just participating in this panel and thinking about the issues over the last few weeks is just that sometimes we have to think about traditions in terms of education. Who gets into the room and how do we get into this field and practice? What schools, what backgrounds, what traditions inform our experience here can very much include, that can be included within the definition of minority. And I think it's important as the practice expands that we consider that as well.
An additional thought occurs to me when we think about diversity and what that means. Oh, sorry. I was just thinking the other day about what diversity means and in terms of what perspective you're coming from, right? Diversity against, in what sense? And I was just thinking of a hypothetical. So for example, if a Korean kind of client comes to me and says, I have an international arbitration for you, and it's a Korean case, so it's a Korean company, as Korean witnesses, Korean language documents, and I'm thinking about how I put together my team and how I think about, what team should I put together. I'm thinking about the cultural things, I'm thinking about the language skills, and I put together a team that's, entirely 100% Korean, let's say. Is that diverse, really? I mean, I think from some perspectives, if you look at it from externally, you say, great job, Charlene. You've created 100% diversity. Everyone's Korean, nice work. When in reality, you lose the great benefit, I think we talk about with diversity, which is the variation in perspectives and putting more of those voices and perspectives in the room. So that's, something I think it really matters from whose perspective you're thinking about diversity in order to understand what people mean when they talk about it.
So then I will not allow you to duck answering a question, Apurva. What I'll do then is picking up on sort of the excellent points that Charlene and Jordan made, and some of the comments both from the panel and the audience in the last session, sort of recognizing that international arbitration, by virtue of its cross-border nature, picks up on sort of a lot of people of different ethnic backgrounds, different national backgrounds. It's a multicultural profession. So let's perhaps push past the question of minorities and diversity, having interrogated it for 2.5 minutes, and ask the more pointed question. Is there an underrepresentation problem in international arbitration among practitioners? And if so, is it more or less acute than more broadly in the legal profession?
Sure. So, we heard earlier this evening about the underrepresentation issue in the context of arbitral tribunals. But, if we're talking about the other side of the equation, which is counsel that advocates before these tribunals, I think we have just as severe, if not more so, an underrepresentation problem. And the difficulty in talking about this is that information is sometimes hard to come by in this regard, because when you're looking at the demographic makeup of arbitral tribunals, you have institutions regularly publishing these statistics, and they don't look great. They're getting better, but they don't look great. For counsel, on the other hand, that information is largely not there. And so we have great work of Professor Davis, Professor Susan Frank similarly published a recent article, and it's based on different empirical methods, surveys, and the results are similar to what we have talked about in the context of arbitrators, that when you look at counsel who are advocating before international arbitral tribunals, there is a severe underrepresentation problem. Lead counsel especially are more likely to be from developed states, in particular Western Europe. Natalie, as you mentioned before, they're more likely to be male, and they're more likely to be of a certain age as well. And all of those issues are important when we're talking about whether we have a representation problem in the context of counsel. The second part of your question was, does it relate to the broader legal profession, or is it something unique to international arbitration? And again, like my colleagues have mentioned, it really depends on where you're looking. If we're looking at different countries, they each vary in their experiences with diversity in the legal profession and the root causes of the nature of diversity in each country. If we look at the U.S., for example, for many, many years, women have been they represent about half of law school students, half of entering law firm classes. Minorities also have represented about a quarter of law students and associates at law firms. But then you look at the partner levels, and women 10 years ago represented 16% of equity partners at American law firms. Right now they represent 19%. And so if we're to continue at that pace, it would take another 100 years for there to be gender parity. Minorities, similarly, they've long represented a quarter of law students and incoming associates, but they represent only about 9% of partners at law firms. And so although that data is kind of industry-wide in the U.S. legal profession, if you were to extrapolate it to the arbitration industry, and empirically, I think this is the case, that the rank and file team members among counsel, they could very well be diverse. But then when you're looking at who's lead counsel, who's doing a lot of the advocacy before the tribunals, who is stepping up as a leader in this field of practitioners, that diversity problem is still there. And so that's something that we would kind of need to address. The last point I'll make in this regard is, I spoke about the U.S. legal profession generally, but the arbitration community is unique. As you mentioned, Natalie, it's cross-border, it's cross-cultural. And so I think as arbitration practitioners, we have a unique opportunity to be leaders in the American legal profession in terms of diversity. And we see that in some respects in the context of counsel, because a lot of case teams, they involve lawyers from different jurisdictions. U.S. law firms are bringing in visiting lawyers from other countries and interns and their associates as well. But again, we look at the partner levels, we look at the leaders of practice groups, and that diversity kind of falls away, right? And so that's the one thing that we need to examine is what's the cause of that, and how can we actually fulfill our role as a beacon of diversity.
Any additional comments?
I would add one point just to supplement it, because I agree with everything that Apoorva said. And this thought comes from actually Professor Davis's opening on giving us thinking more broadly about, transnational trade in the history of the world, because nothing is an island into it of itself, and that's very much true of international arbitration. And it just occurs to me, it's a point that we have often made at my firm about, who's in the room when we're talking about diversity and how do we think about our practice. There is, of course, an inclination to focus on counsel and on arbitrators. But when you look at the wideness of the practice and who actually contributes to getting the case through the door, from our experts to our paralegals to the staff at arbitral institutions, it's actually a much broader group of people there. And I think it's important that we consider the diversity within those spaces as well, because those are the natural pipelines that get people interested and acclimated to the field, that allow people to see themselves in the room in ways that are not traditional.
About a year or so ago, there was this initiative, I think in the federal courts, which basically said that litigators come to federal courts should have women or people of color have a direct impact or a very productive role in litigating cases in the federal courts. Do you think with regards to counsel in the international arbitration community, do you think there should be some initiative there to have, women and people of color in lead roles in the international arbitration community being given lead roles if they're not already?
I will answer in about 30 seconds and then ask the panelists to consider this, because we're going to circle around at the end and talk about tools and techniques. The short answer is I'm not currently aware of any initiative to help raise the profile or sort of offer real stand-up opportunities for women and people of color. I am aware of initiatives for younger lawyers, which is another sort of dimension of diversity that was mentioned earlier. Perhaps the most official version of these initiatives, frankly, Young ICA is an example of such an initiative. But if you think about the role of institutions, for example, CPR, which was one of the institutions that was mentioned earlier, has recently introduced a rule called the Young Lawyers Rule, where essentially by agreeing to arbitrate under the CPR rules, it authorizes the tribunal to essentially encourage the parties. Encourage, as we know, when it comes from a tribunal, bears a little bit more weight than just an exhortation, but encourage the parties to actually give younger lawyers precisely stand-up opportunities on their matters. So in some ways, like the ice has been broken for having a little bit more than just expressions of hope that things will change. But I take the charge. I put it to the panelists, and we'll circle back. So let's kind of pick up beyond some of the broader observations that Apoorva has made and start getting a little bit personal. So Charlene, if we're speaking about sort of the issues of underrepresentation, of opportunities for women and people of color, speaking from your own experience, are there barriers to entry or obstacles that you have experienced over the course of your career that you are willing to share? And the rest of the panelists know I'm starting with Charlene, but I'm going to come to you as well. And if you have experienced those obstacles, how did you prevail? How did you overcome them, assuming that you have?
Sure. So I should start off by saying I think I've been relatively lucky in my practice in international arbitration, in the sense that I've been fortunate to have very diverse teams, diverse mentors, and I can't say, at least that I'm aware of, I've faced any kind of one enormous obstacle as a diverse attorney in international arbitration. So I've been very lucky in that sense. That being said, reflecting a little bit on my experiences, I do think there are these little instances that seem innocuous on their face that ultimately speak to some of the broader issues that I think we face as diverse attorneys, generally, and also more specifically in arbitration. So I'm going to point to just a very simple example. It's by no means the most dramatic, but as a junior lawyer, and even as I've gotten more senior, and specifically by people who don't know me very well, you know, external counsel maybe, or opposing counsel, clients, you know, whoever else. I very frequently get confused with a different Asian American attorney. And I'm sure that's happened to a lot of us before. And I wish I could say it happens less as you become more senior, but the most recent example I have is just last year, I was in a merits hearing, and I was delivering the direct examination of a witness. And as many of you know, you have the little screen in front of you that has like the real-time transcript that you can follow along to check your questions or the answers. And something caught my eye on that transcript because the transcriber had been putting the name of a different Asian American attorney for my name when I was asking the questions. And you know, I noticed that, and I was like, oh, that's going to be really awkward to correct, but I'll correct it later. And I did, and it was fine. And you know, we had a good laugh, and you know, it was water under the bridge from that point. But you know, you can imagine as a junior attorney, when you already feel like you are kind of fungible and you're just another cog in the wheel, how it might feel to be constantly confused for another attorney who kind of looks like you. And so it's these little kind of assumptions that you face, these little shortcuts that people take, but I think ultimately, you know, speak to kind of your experience and how you feel about your work more specifically.
Apurva or Jordan?
So I too have been fortunate in that I haven't experienced any sort of overt barriers to my, you know, entry into this field. But you know, generally, you know, I do have experiences where I felt sort of implicit or maybe more explicit biases in terms of belonging as a member of a minority group, belonging in the legal profession generally. You know, I've had experiences where certain, you know, more senior lawyers kind of ask questions that indicate I don't belong as part of the group. You know, what are you doing here? Why are you here? What's your background? And the kind of questions they ask about family history and cultural background they kind of suggest, perhaps inadvertently, that, you know, I haven't seen many people that look like you as a lawyer before, right? And it's kind of strange to them. That doesn't necessarily mean that they doubt your abilities, but that sort of implicit bias that, you know, this person doesn't look like everyone else I've worked with in my career. And so maybe they're not going to be quite the same, you know, is there. And I've experienced that. And I think many people in this room have experienced similar things. And Natalie, your follow-up question was, so have you dealt with that, right? And that's very difficult because I've struggled with whether do you call out these kind of actions, or do you just go by that adage where, you know, if you're a diverse attorney, you have to work twice as hard to achieve the same results, right? And sometimes I've just gone for the latter option, and I've just, you know, showed up and been proactive and strove to deliver excellent work, and eventually kind of proven myself to belong, you know, in these spaces. I don't know in retrospect whether that was the right approach, and that just doing that was the right approach. Maybe there should have been more I should have done. But sometimes it has been kind of that kind of uphill battle to be someone who doesn't look like other people in the room.
Jordan?
Like the other panelists, I'd say I've lived a fairly charmed life. We three lucky people. In the sense that my work has never been challenged or disregarded because of, as far as I can tell, anything about who I am. But I will say that a challenge that I continue to encounter and navigate, not always successfully, has to do with things that are not immediately apparent about myself, you know, at a distance. People can obviously see that I'm of color, that I'm a Black and African-American man, but, you know, I have often encountered over the years with working with clients that moment in between, you know, examination or at the closing dinner, or where we get into the personal aspects of people's lives. When I was early on, and the fact that I was gay, there were very many clients who bristled. And that's a function of this conversation we're having about what does it mean to be diverse in this field, where there are very different temperatures on certain aspects of diversity around the world. There were instances where, you know, the notion of a closet is not something that, you know, you step out of and it's gone forever, where I stepped back into that closet for lack of a better option, avoiding pronouns, you know, avoiding conversations about my significant other or things like that. As I've gotten older and I've, you know, started to give less, you know, I will say the rest of that It's been less of an issue, but it is something that I'm constantly cognizant of when I'm thinking about my clients, and particularly in social spaces. So I think it's important to say that it's not always successful, that I've navigated it, and sometimes I would consider it a personal failure because I would never, particularly in an American context, I've never hidden that aspect of myself, but in the specificity of the international arbitration practice, I've felt that obligation sometimes.
The obligation to speak up, to say something?
No, to hide.
The reverse.
Step back into that class, yes.
Okay. One question before I move to the next one. All of the panelists routinely speak at conferences or sort of within your firms or externally on questions, matters of, international arbitration practice, right? How many times have you been on a panel that is as diverse as this one?
Never. Yeah.
Ever?
I won't say never, but it was specific to like this question of, recruiting, which is always where we made a joke earlier. There's a firm that's like, oh my God, if I could put all you on a pitch, it's like, oh, it would be great. But it's a particularly special experience because it's rare.
One thing I will say, there are a couple of times when I have been on maybe a panel that's maybe like half as diverse as this one, and you do celebrate those opportunities. Whenever we are talking about diversity and inclusion in anything, including in international arbitration, coming back to one of your points, Apurva and Jordan, it matters kind of who's in the room. The panels that talk about diversity and inclusion almost always look like this one. Which is why I am delighted that we do have people in the room who do not look like necessarily the people on this panel. But moving to, picking up on A, the title of the panel, and B, some of the points that we've made before, let's start talking about a pledge, sort of a minority pledge in international arbitration. So we're all agreed that there is an underrepresentation problem, both, I think, generally, if we look out at the profession, not necessarily just looking out at this room. If we have personally experienced some of these challenges ourselves, one of the potential solutions that will sometimes come up, and I think it comes up more frequently in recent years, is, well, a pledge can work. So I'm going to pause for a second. How many people know about the equal representation pledge? Just a show of hands. Okay. So let's have just a little bit of level setting. Equal representation pledge, or the pledge, you can imagine the capital letters, is an initiative of largely a group of women in international arbitration to push institutions, arbitration council, arbitration parties, to really kind of step up to where the rhetoric has been for quite some time on gender diversity. So the idea was you actually kind of reduce all of the exhortations to a few bullet points, and you challenge people, sign up to the pledge. And if you sign up to the pledge, then you actually sort of do what the pledge says you should do. So what does the pledge say? The key elements. The goal is broadly to improve the profile and representation of women in arbitration, although it is focused on the appointment of arbitrators, so not as much the profession as such. It is phrased as a challenge to and requiring the commitment of stakeholders and players in the field. So parties, arbitration council, in-house counsel, other arbitrators who, as we know, frequently refer, or if they are chairs or co-arbitrators, appoint each other, and arbitral institutions to, and here is the shocking standard and the requirement, include a fair representation of women. That's it. So include a fair representation of women in the list of candidates that you put forward, include a fair representation of women on the tribunals, include a fair representation of women on the panels that speak at the conferences on the near interminable International Arbitration Conference circuit. And it includes two important things that I think both expand the scope of the pledge beyond just arbitrators and give it a little bit of teeth. So it actually ends with an exhortation to senior practitioners in the field to support, mentor, and sponsor, and encourage women to pursue arbitrator appointments and otherwise enhance their profiles and practice. And second, it calls for the collection and publication of statistics on the gender breakdown of appointments, i.e., actual numbers that you can use for transparency and accountability. That's how we know, frankly, that the numbers are ticking up or are moving or not moving. That's how we know the breakdown between how many women are appointed by institutions as opposed to how many people are appointed by parties. So, given that that's kind of the scope, and again, the groundbreaking include fair representation of women goal of the Equal Representation Pledge, is a minority pledge needed? And would it have made a difference to you when you were coming up the ranks, whether as a law student or as an associate? So Jordan, we'll start with you.
Yes, absolutely, it's needed. And when I say that, I want to be clear that I think when we say need and achieve and get, because I think we can think about those pledges in two different ways. One is while they're still in this formative stage, the conversations they engender. I think sometimes we often think that this question, because of the challenges we've talked about as to what a minority looks like, what does it mean to be diverse, that it's an intractable problem in international arbitration. When you're to respond to a point from the past panel, when you're in a situation where it requires a particular language expertise or familiarity with a, I shouldn't say niche, but a less common area of the law, and the field there is just, what it is. What does that mean? And what does it mean when one's a signatory to such a pledge? I think the conversation around the pledge is equally as important as the actual distillation of the pledge to paper, because I think it gives us an opportunity to speak with people about, well, one, what does the pledge look like? Two, how do we assent to it? Is it an individual thing? Is it an institutional thing? Is it a firm thing? And those conversations are important. They're important both for keeping it top of mind for people who would rather not have this conversation, but they're also important as a practical, way to understand where people are on this issue. I find that important in my practice to understand both for my colleagues, my opponents, my tribunals, my clients are on these issues. And so when I say need, I think we have to be clear that the need is for the conversation. But on the other half of it, I do think it needs to be distilled to paper before a point that Uche made about how do we actually take this to action. And part of it comes to when you think about an international arbitration, we say consent is, key. It's the arbitration agreement by which, before a dispute arises, that people are able to bind themselves to certain agreements about how to manage the dispute. And I think when you have a pledge that has teeth, that gives you an opportunity to say that, you've committed to this. It gives you something to hold up and, to hold them accountable by. The question is, how does that pledge work? The pledge, if it were to take the form of the Equal Representation Pledge, you could imagine that it is, a very broad commitment to including more diverse people, both as counsel and as arbitrators. There are other forms this could take that exist out there in the field. The Mansfield Rule 2.0, which talks about, for firms and this whole counsel question, about 30% of whenever you're considering for senior leadership positions, 30% of the people that you will consider will be diverse, women, people of color, LGBTQ+, which is based on the Rooney Rule or was inspired by it in the NFL. And that's a different form of pledge with a different metric for accountability. But yes, I say yes, resoundingly.
Charlene or Apurva?
So I would agree that a pledge would be helpful. The question is it enough, right? And the key question is accountability and transparency, Natalie, as you mentioned toward the end of your comments. If we focus on counsel again, moving on from the topic of tribunals, you could see that, parties to disputes, major corporations in the U.S., they've been issuing various forms of pledges for a very long time, for numbers of years, publicly committing to looking at diversity intently in their hiring of outside counsel for disputes, right? It's curious whether that would apply equally well to the arbitration world, because some of the criticisms of these pledges is that it's a PR stunt, and no one's holding these companies to task in terms of their actual hiring of matters. And so with the confidentiality in arbitration, who's to say that a company coming up with a pledge would actually proceed in looking at diversity intently in hiring outside counsel for a major international arbitration. But I think a pledge is a good first step, right? And so we should, of course, these conversations about the actual structure of the pledge, how it would be enforced, whether it would have teeth are critical. But the fact that a pledge exists means that someone is willing to stand up and raise their hand and say, this is important, that we have diversity in this field. And that would have made a difference to me, coming up through the ranks. When I was a law student, I knew I wanted to do international arbitration. I didn't see really anyone at a major firm who kind of looked like me, like a role model I could emulate or get to know. So I wondered, am I going to cut it in this field? And I stuck with it, and thankfully then, since entering the field, I've seen many, many diverse, fantastic lawyers in the field, but I didn't know that existed when I was kind of an ill-informed law student, right? And many people would have been dissuaded if they kind of looked at different practice areas they could have gone into, and they say, well, I see there's more diversity in other areas. Maybe I should go for that. Maybe I have a shot at cutting it in the law firm world. And maybe they've decided to kind of turn off of international arbitration. So I think the fact that a pledge would have existed may have made the difference for a lot of students.
So I don't want to repeat too much of what's been said. All I'll say is I absolutely agree. I think that a pledge in any form is a positive step. Obviously, something with more kind of teeth, more kind of enforcement mechanisms would be fantastic. But the act of having a pledge and making it a priority, and getting law firms to sign on, I think, as everyone has said, kind of puts it to the forefront and starts the discussion that I think we very much need to have in arbitration. In the context of whether or not it would have made a difference for me, I think it probably might depend on what it says. It's
appropriately lawyerly response.
But I mean, ultimately, we talked a little bit about, opportunities for stand-up experience, for example, for diverse kind of international arbitration attorneys. If that pledge memorialized something of that nature, it said that, we're going to make a commitment to give more stand-up experience and oral advocacy opportunities to more junior attorneys. I mean, how amazing would that be, right? And what a great kind of thing for an international arbitration to have when you don't really see that, I think, in other practice areas, or at least I'm not aware, speculating now, but I'm not aware of anything of that type in other practice areas.
Yes, sir.
Hey, my name is Francois Estrada. Very pertinent question for me. I'm a law student as well. I see myself as a diverse minority student, but with something like the pledge that is currently available right now, it's easy to tell. It's a man or a woman, and it's easy to see. Going back to Nana's point earlier, that you need it's not just the minorityness, it's also the diversity that this person brings to the team. I guess my general question would be, like, how would you be able to tell, let's say somebody from Nebraska who is a first college-time student, but he happens to be white. It seems like this is a circular argument that he is diverse, yeah, but then we are not jumping up our numbers in terms of minorities.
I mean, it's an excellent question, and in some ways kind of presses us and pushes us, sort of, what is the problem, what is the challenge that you are seeking to address, and how does the way that you define that problem and the tool or the solution that you're proposing actually match up? And then where does it leave real people who are actually trying to enter the field? Sorry, was there a comment on that one? Yes, please. Into the microphone.
I guess it's on?
Yes.
Okay, so my only claim to fame is Ben Davis's sister.
Welcome.
All right. I'm the oldest. Anyway, I'm getting, whatever your word was, agitated with certain words, and because of our own, Ben and my background, we're foreign service brats. We were born into international. We had no choice, but we supposedly represented the U.S. that we didn't know. okay? And we were born into Liberia, Nigeria, Tunisia, and Switzerland, okay? So that's our diversity. Our frustration throughout life has been being accepted here because we were limited to black, or, well, not white, but black, and whatever black is defined. And it's very limited in definition. When Ben decided to go into international law, he had to leave this country and go to Paris. And that's where he started his international law, because he knew that the law firms here were not even going to look at him. Okay, when I was in journalism to some extent, I wanted to be an international reporter. They told me I had to spend 20 years. I said, I spent the last 20 years growing up internationally. Why do I need to do that? So I guess what I'm saying here, there are questions I have. One is, why define yourself as minority when you're talking international? I don't understand that. Why put women, or yeah, let's say this, women in the same category as, quote, minority? We're 51% or whatever it is. And at the same time, women, what has happened in, quote, affirmative action is that white women get the bulk of the activity, and then they're counted as gender. And black women, Hispanic and Asian and so forth don't get it. And I just bring that up because we're talking about international. We're not talking about national, right? You are operating at the vortex of national and international. And you have to see what the other guy is saying. There are more people like us out there than there are in here. And we have to connect the dots so that they understand what's happening here and we understand what's happening there and can translate it to each other. I'm sorry, but I mean, I work with the UN and all this, and I go through all this, but I really need to say that so that we're not stuck in a box and it's not just our problem.
A number of very important threads there. Thank you. So I'll kind of pick it up with the panel as well. Again, pushing us to say, you know, why are a young person who is either grown up in the United States or, like me, came to the United States and you want to break into this field, you are still faced with the challenge of, given that this is the body of people that I'm going to be working with or persuading to hire me in the first case, is there a challenge? Is there a problem? Is there an underrepresentation problem in the environment in which I'm going to be working that I have to deal with anyway? And then on gender, all I can say is, in some ways, I think, at least on this panel, you may be preaching to the choir. That you know, the whole idea of having the minority pledge, as different from the gender pledge, is that you don't want to confuse the two. So I'll come back to the panel. So one of the things that we have heard, and I think we repeatedly hear in conversations about moving the needle on this, is when you're talking about counsel, what matters is clients. Because it's the clients who will determine what firms do. It's the clients who will actually encourage people who may not otherwise be true believers to do things. So in your experience, have you seen the same kinds of client pressures in international arbitration matters or international arbitration practice that we are beginning to see in litigation or other counsel teams in the US?
I have not, to be honest. You know, I'm aware that in the litigation context, in the context of domestic litigation in the U.S., you know, many clients have concerted specific policies and concerted efforts to ensure that they are considering minority and women-owned law firms as their outside counsel, to place them on panels for repeat litigation, to ensure that the legal teams that they hire for various matters are diverse. I haven't seen in my experience that also happen in international arbitration. And thinking about why that might be the case, you know, in the earlier panel, you know, we heard comments, you know, explaining that, you know, well, when there's a life or death or bet the company matter, when a party has their only major international arbitration that they may have that year or that decade, for instance, then they may have a different approach than to the run-of-the-mill litigation that they have dozens of in the course of a month or a year. And so they may not care about diversity. It may not be on their radar. And so whereas they have the quote-unquote luxury of considering diversity and enforcing diversity efforts in the context of domestic litigation, that may take a back seat in the context of a major international arbitration. And my response to that would kind of be to think about the role that a pledge might be able to play, in resolving this question. Jordan, you mentioned that, the Mansfield rule, and that kind of was inspired by the Rooney Rule in the NFL. Are people familiar with that? Have people kind of heard of it? Yeah. So I see some yeses and nos, but I'll be very quick about this. The Rooney Rule was a rule instituted in professional football in 2003, I think, basically saying that for any head coaching vacancy, a team is required to interview at least one minority candidate, right? And the question is, okay, well, your reaction might be, well, is that going to actually achieve anything? Because, of course, everyone will bring in a quote-unquote token minority, interview them, not give them the job, and comply with the Rooney Rule. But if you look at the statistics today, after that rule was implemented as a policy, the number of minorities that have been hired as head coaches, and again, right now there's only 32 teams in the league, only 32 positions, it's doubled. And more detailed studies have shown that if you're taking into account other confounding factors that might explain the increase in diversity, that pledge alone, the Rooney Rule alone, has increased diversity among coaching hires by over 20%. And then you look to the Mansfield Rule. That was something implemented about 2 years ago in law firms, where they, as Jordan explained, law firms step up and they say that they're going to consider diverse attorneys for things like equity partner promotions, lateral attorney hires, searches and consideration for leadership and management positions in firms. And the results are still kind of coming in because it's a new initiative, but it seems to show a lot of promise in that firms that weren't thinking about this intentionally before are now actually, again, it's about equality of opportunity, not necessarily requiring someone to hire someone just because they're diverse. It's just about getting a seat at the table, and that does lead to results. And so I think in terms of do clients implement policies or practices to increase diversity, I think a pledge just, committing to, when you have a major arbitration, for example, as a party, make sure you bring in a pitch team that is actually diverse, and make sure that when you hire outside counsel, the people that appeared in your pitch are actually the ones doing substantive work on the matter and not just kind of disappearing on the bill. That kind of pledge, maybe it will have teeth, maybe it wouldn't, but I'm optimistic that it would lead to some degree of results.
Charlie or Jordan, final thoughts?
Sure. So I'll just add here. So I've had a very similar experience in the sense that I've seen these kinds of pushes to have more diverse teams coming from clients, mostly in a litigation setting, and not so much in my international arbitrations. And again, thinking about why this happens, I think actually context is extremely important here once again, in the sense that, and for my litigation matters at least, I'm very often working for like Western or North American clients, right? And there is a big push right now, I think, among these companies to think about things like diversity and who they're hiring as external counsel, things of that sort. I don't know necessarily if that same conversation is happening in the same way, at least, in other jurisdictions. So understanding how that conversation is going on there, what they mean when they talk about diversity, how is it important to them? And those clients in other jurisdictions, I think, is extremely important to identifying why maybe the clients are demanding it less in international arbitration.
I think the only thing I would add is to go back to the 2 points that were made earlier. One about, how do you know who is a minority and how do you define that? And the point about why do we say minority in the international arbitrations field? Because I was struck earlier by the comment about if you were to assemble a panel that was one woman, one man, one person of color, to have a sense of artificiality. And I think we have to change kind of our perspective on this about, one, what is artificial? I think the artificialness is the fact that traditionally it would have been a room of 3 men, all white, all of a particular background and education and experience. That's what's artificial, and we're trying to subvert that norm. So I take your point about why do we say minority when really what we've said on both panels is about, making sure that these panels are reflective and council are reflective of the world we live in. That gives them an air of legitimacy. But to your point about how one defines minority, I think that's the challenge that's incumbent upon all of us. We all, in our jobs as counsel and practicing international arbitration, take very seriously who we present to our clients and who we suggest for panels, who we suggest for experts, who we suggest as local counsel. And part of our thought process there has to make sure that we're checking our own norms and biases and experiences. Simply because I fall into what people would call a bucket of minority doesn't mean that I don't have my own blinders. I think it's very important, because I think the start of your comment was about taking someone from Nebraska. It's not lost on me that I'm sitting on a panel that I think where we all went to Harvard Law, and that we all practice.
Right? All of us did?
I think so. It's a failure in this regard. But these are biases that we all have, and I think that as we think about a pledge and what form and shape it takes, of course, I am not someone who thinks that diversity of thought is equally as important as diversity of gender, of ethnic and racial background. I think it is important, and I think we do have to do a service to those groups that have been marginalized in ways that perhaps the diversity of thought has not. But it's important to consider. It's important to consider as we think about a pledge. It's important to consider and how the metrics and the data you would collect, because it ultimately comes down to better client service. When I think about selecting a panel of people who all come from the same tradition, experience, who are from the same universities or from the same law firms, you have to question. We say that there will be a diversity of thought process because of their own life experiences, but who's to say? I came up in a big law firm in New York, practicing a particular way, and I'm sure it's very similar to how Apoorva, Charlene, and Natalie came up. So it's a good point, and I think that the pledge, the challenge that we have is figuring out how to address all those nuances.
Thank you very much to everybody. In many ways, I will apologize, but I will say that I think that we did our job because there are hands in the room that I'm going to have to ask you to move those conversations into the reception part of the evening. Otherwise, we will be here forever. So if you will join me in thanking our panelists. Please do stick around for the reception and for the speed mentoring. If there's anybody that you want to buttonhole in particular as we come off the dais, please do so. But remember that there is more of the evening that we have to get to. Thank you all very much.
And just a quick note for anyone watching this in the future online for CLE credit, the CLE code is 1694206. 16942, thanks.